You should already know when I walk in the door that it ain't no use in frontin' on me.
Let's go.
I'ma hustle, I'ma do my thing. You already know
DJ Top.
I keep hustling, I keep hustling, I keep hustling, I keep hustling.
Good afternoon. Good afternoon. What's happening? What's happening? How y'all doing this weekend with this hot weather? You know what time it is. I gotta go all in one more time. You know what I'm saying? You know, because cats be like, why you do that? They've been getting away with it for too long, so, we gotta close that door. So, on that note, we're gonna go right into it. Basically, I'm gonna go into the New York State Division of Human Rights. We're gonna go there because of the simple fact that when you file a complaint, and you gotta peep between 2010 and 2012 how they changed everything around to cover up the screw ups they was doing. So like by 2010, when you would file that complaint, you would have basically 45 days for them to respond. It was later changed to 60 days. That's business. But we're going to go into the fact of how when you file this complaint, right? Once you file it, they got to make notification to your employer or whoever it is you're filing against. Now, they tell you, it's in their documents right there. You can Google this. It says, once you file with New York State's Division of Human Rights or EEOC or New York City Commission of Human Rights, once you file with one entity, it's automatically passed on to the other entities. You can't file there. Now, what they do have is something like 180 days. So they basically have 6 months to basically get back to you and let you know what's what in reference to your case. But yet and still, they have what you call that time period of 45 days, which is now 60 days. So if they feel that you have no real case, that there's nothing they can work with, basically within that 60-day period, they'll just tell you, we don't see anything. Here's your documents back. You could try another route. So we're going to talk about the fact of how they initiated the extrinsic fraud, okay? Not intrinsic, extrinsic fraud. The extrinsic fraud is basically preventing you for bringing this matter to a court in the whole 9 yards. It's almost like the appeal process. And then they trying to deny you that right to do so, all right? Once you file with the organization, they gave you that notice in the mail that, your complaint has been filed, and we've notified the second party that you're complaining against, okay, and waiting on their rebuttal. Once that goes out, or once you sign your name, you done enter into contract. They're obligated under contract, under contractual law. They're obligated. Now, the key fact that under that contract, and it stipulates in their guidelines, you can PDF this and bring it down, and you can read it over and over and over. I don't just say look at it, PDF it, so that way you could go over it over and over and over on your own time to get a better understanding. The document will state that basically, like I said, you have 60 days for them to respond, basically turn you down. If they don't, then they have 180 days. Now, they have to do this because of the simple fact that in closing within that 180 days, they find they have nothing, that gives you an additional 180 days, which bring a total of 300 days, because it leaves the window open so you could go and file with EEOC in reference to what had happened, what occurred, how you were discriminated against. Gotta love them, because it's like, all right, fine, there was no case. So let's go there. there was a signed contract agreement with the employee, A, and the vendor for parking. Right? Yes. Okay. So, based on the fact of old boy's actions, dirty director, who said, I don't want him parking there. Granted, you can say that. You can say what you want to say. But you must have supportive document in reference to your actions. You didn't have no supportive document. So your action basically breached that contract. And in breaching that contract, you're denying the person their right and privilege, which will bring about that federal law. What's that? That Jackie Robinson? U.S. Code 42, deprivation of a right or privilege. So you deprived them. So basically, New York State was supposed to acknowledge this. But see, the problem with the machine, they all get in bed and they work together and they feel that most people are dummies because, they dumb. They're not going to do their research. Hello. In today's world, we have what you call androids. Yeah, Android devices. And all of this information is how would you say, under Free Informations Act. So all they have to do is just download the information, find out what are the guidelines, what are you supposed to do under your signed contract agreement, then find out what the employee is supposed to do under his signed contract agreement with his employer. Like, what is his responsibilities, what he's supposed to do, what they obligated to do. Now, you take and you use that. So when they breached a corporate compliance policy, did their corporate compliance policy also breach any federal, state, or local laws? If doing so, then you bring about that charge and you paste it over right along with that. This is what you did. I believe New York City has what you call the reporting for all New York City employees, where they must report criminal activity. Misconduct. It's like 6 of them. Conflict of interest, abuse of authority. It's a number of them. They suppose it's on there. You can PDF it. You can pull it up. Reporting. So with New York City, you have that. So with the state, you basically have the same thing. See, the key thing is when you have these rules and regulations and they violate them, that you can go through the city, or you could go to the state, or you could go to the feds. But we're going to stick with the fact of how the New York State Division of Human Rights violated their own contract. How they violated the contract? They did not forward the information to EEOC, basically, because when you go straight to EEOC is going to say, go to one of your local authorities. Your local authorities, like New York City, the local authority, New York City Commission of Human Rights, and then it'd be New York State Division of Human Rights. So those are the locals. So they say you have to go there first. Granted, went there first. Now, when you go there, automatically they're supposed to send this and pass it on. Here you go to the next entity. But they didn't do that. Let's look at the fact of why they didn't do that. Let's look at the fact that you violated your own corporate compliance policy by going beyond 180 days. See, when you went beyond the 60 days, you trapped yourself. Then the 180 days, you definitely trapped yourself because you failed to do what you're supposed to do under your signed contract agreement. Okay? Now, let's go forward. You didn't forward it to EEOC. You didn't contact the complainant. But you held it up for 791 days. And within like 700 and I would say 70 some days or whatever. If it was filed in June 2010, you didn't assign someone to review the case until August 2012. Now you got to understand, under policy and procedure, there were several other officers who filed. And basically, within that 6-month period, they all got their decision. They basically got their decision. What was the cause and reason for delaying for so long? And then the assigned investigator basically says, yada, yada, yada. Doesn't even tell you why it was delayed. But after making their decision, they say, I made my decision. I find there was nothing done wrong. And good luck with attitude. So basically, as a law enforcement officer, that sends off signals where like something's wrong here. Good luck. Getting emotional. Why are you getting emotional? Good luck. Let's do some investigation ourselves. Seems like you didn't file in a proper time. Seems like you violate your own corporate compliance policy. By breach of what? Of contract. Signed contract agreement. By breach of what? Your duties. Oh, I did my duty. You sure? You sure? Because you didn't do it efficiently. Like I said, the director did say he didn't want the officer parking there, right? Yeah. Okay. But the officer had a signed contract agreement with the vendor, right? Yeah. So for the director to take such actions against the officer, he had to have cause and reason. Am I correct? To violate that contract, that signed contract agreement. What was your cause and reason in just singling out certain people? Especially when these people had no major problems. They had no major problems with the vendor. So what was your cause and reason? Better yet, was it done because of the simple fact you broke the law by using your vehicle in a threatening manner? You say you was an NYPD officer. And you, detective, and you use your vehicle in a threatening manner towards somebody? Was you having a training day episode or something? I don't know. It's kind of funny. But when you do the math on all of this, you can see it's very simple. It was the machine. And accountability must be held on each and every last one of them. Granted, he was terminated. Granted, the labor relations director was terminated. But we must get those others that was involved, that was informed of this violation. There would be no parachutes. No. See, because you were obligated under your signed contract agreement as an employee, once the officer came to your office and told you what occurred, you're obligated to go and pass that on to the corporate compliance officer, who passes on to Department of Investigations. See, we like dropping the ball. No, we're going to pull this train. We're going to pull this train. It's real simple. It's all documented. It's all documented. It ain't hard. We look at all of those a lot. This case is just totally ridiculous. You got the judge line from the king on down. You got the senior vice president who's giving out parachutes. You got the judge line. You got who's violating his canons by ultravirus. You got the lawyers violating their canons by ultravirus. You got the New York State Division of Human Rights. They're violating their corporate compliance policies. Come on. Come on. I could see if these officers was doing something, but no. What was your basic goal in doing this and allowing this to proceed? You just made, and then and in the end, you took and changed the name of the organization. Listen, no matter what remedy is there, because your decision on the judge under the improprieties, I recommend termination. Do you know what improprieties is? Under your canons 2's the judge. Under your canons 9's lawyers. Impropriety. Google impropriety. I'll tell you right there. This guy broke laws. So right off top, this one has been thrown out. The sergeant lied, going to give the officer a directive while the officer's off duty. You better get over here. Did you sit in the vehicle? No. You do have a patrol manual, right? Yeah. Page 54. Paragraph C. All supervisors are to assign the patrol officer to the armed PD for transportation, for official transportation of personnel. You were so hooked up in your emotions, you failed to do that. So your insubordination charges, that goes in the toilet right there. There's your impropriety. Goes in the toilet. Let's tell the truth. The mere fact of the other supervisor, he cursed at me. Officer Maxwell, love that, bro. Officer Maxwell told me when he relieved me, he said, once I returned outside the 124 office, he said, yo, they try to get me to write a statement saying that you cussed, and you didn't cuss. So this is a supervisor. The supervisor is going to take his own memo book and write a lie in his memo book and going to take it and bring it to court as evidence. You wrote in your memo book, right? Yes. So your memo book is basically a official document. It can be used as an official document, right? Yeah. And you writing this information in your memo book of an incident. Yes. Basically punishable, right? Yeah. So 21045, writing a punishable instrument, writing a statement for the record. It's a Class A misdemeanor. The mere fact that you took that and you filed it along with others on the record, we're going to go to 175-30, which is often an instrument for filing with false written statement. And if you anyone that came after that supports this 175-35, often an instrument for filing with false written statement is a Class E felony. You gotta understand, yeah. And you perjured yourself. The key is you wrote this in your memo book 2 days later. I'm not even gonna go to the page, but you're another supervisor. And in that very same patrol guide, what it says, how do you fill out your memo book? It has to be in chronological order. I work for 3 law enforcement entities, and I never seen where it said that you write in your memo book today, and then 2 days later, you can write what occurred today in your memo book that day, as if it wasn't corroborating. You're a supervisor. Number one thing a supervisor was supposed to do, by my experience, is once the incident occurred between the 2 supervisors, the supervisor was supposed to tell the officer to step outside. And then the 2 supervisors discuss the matter and what was unacceptable as far as the tone. But yet and still, if you want to say the officer did so, your actions were supposed to be to take and write the incident in the officer's memo book right then and there. Then record it in your memo book right then and there. Then record it in the 124 book right then and there. Then write the incident up on 587. You would write it up on a 587. Submit it downstairs, and then later on you would submit it upstairs. You ain't do none of that. And you're a supervisor. Do you understand what that means? Oh, I forgot. You was too busy putting your heels on the table, on the desk. It's called responsibility, baby. Responsibility. I don't know. This is just quite comical. And you say, well, why you keep talking about it? So none of you idiots would try to do this to anybody else in the near future. How about that? Because the facts, they can't be altered nor denied. And on that note, have a wonderful day. I'm out.